Okay, great. So, hello everyone. Thank you so much for coming. We have a very informative show that we're going to bring to you today. And just if you don't know who I am Charles Galliard. I'm the CEO and founder of CG Wealth Solutions Group in New Rochelle. I have 32 years of experience in the financial services industry. Right. My primary role within the organization is to build award-winning sales agencies by bringing individuals, families, and small businesses together in our quest for economic empowerment, closing the generational wealth gap and the achievement gap, and providing very valuable information about retirement planning, small business problem solutions, estate planning. Also, we deal with life insurance as well. We are a very small firm based in New Rochelle, and we have grown to 76 reps in 6 years. And we are licensed by the Department of Financial Services to do business in over 30 states across the country. For more information about the team and CG Wealth Solutions Group, please visit our website at www.cgwealth.financial. Once again, cgwealth.financial. Today we came to discuss the very important topic of estate planning and the importance of wills and trusts. And delivering this very impactful presentation today will be my good friend, Eileen Marcial, who is the CEO of Wills Trust and More. So if you have questions throughout the presentation, I meant to share my screen. Hold on a second. If you have questions, if you have any questions through the presentation, you can feel free to place them in the chat. I'll be sure to capture all questions and we will address all these questions at the end. So put them in the chat. We'll address the questions at the end of the presentation. And if we have time, we'll unmute everyone and then we'll have an open town hall discussion. Okay. But before we begin, I just want to get the compliance situation, out. Just to let you know, I told you who we were, and I'm gonna let you know who we are not. So we are not licensed attorneys or certified public accountants. We do not provide legal or tax advice. But what we do, we really connect you to the legal team and to the tax team. So for guidance on your specific situation, you want to consult with a qualified legal or tax professional. The information provided in this presentation is for educational and informational purposes only and should be not considered legal or financial advice. So with that said out the way, I do have a special gift for everyone who is joining us tonight. If you see that QR code, you can scan the QR code, and it's regarding the estate plan and retirement planning. We're offering a free consultation, actually a free financial plan for everyone who is on the call. If you scan that a QR code, it'll take you to a link, Planswell. You'll see like a little squirrel pop up and crunch your numbers. And if you have any retirement plans, it'll tell you where you need to be, where you are now and where you want to be and where you want to go in the future. It's a handy little tool. It'll put together a nice little financial plan for you. And of course, if you want more information, you can call us and we can go deeper into the process. All right. So with that said, I have a poll. Before we get started, I just have a poll I want to launch, and hopefully it works. Did it work? Do you see the poll? So you
Yes.
have to bear with me. This
Good.
is new. I'm trying to be fancy, show you my technology skills.
You better than me,
Right.
bro. You better than
All
me.
right.
You're good.
All
You're
right.
doing good. Doing good.
I'm trying there, right? So we have a poll. So the first question is, do you have a will? Right. So do you have a will? I'm curious. And everyone just take a minute and just check what your response would be. And the answers are yes, and it's current, yes, but it needs update, or no. I'm just curious to what that is. And the second question is how many people that you know have a will. So the first question is, do you have a will? Second one is, how many people that you know have a will? And just take a second to complete that. I am curious. I think I know a lot of what the answers will be, but I may be surprised. I may get shocked. Right. So we have here. Um, Look at that. 82% says no.
Wow.
83. That number is growing.
Wow.
And don't feel bad about that. We're in the financial services industry, and I can tell you, if I talk with 10 clients, maybe one has actually started it. right? Maybe one has actually started it and hasn't finished it. And the second question there is 46% says, I don't know. All right, great. So thank you for that, everyone. So with that, I will step aside and we have the Bishop Linda Small Spence today, and she will, we'll take it from there. And so
Good
Linda, it's on you.
evening, everyone. So glad that you are all here. I am here to tonight to introduce our special guest, um, and I'm going to read her bio for you so that you'll know exactly who she is. Eileen M. Marcial is the founder and CEO of Wills and More LLC. She is a $100,000 ring earner and is the 2023 Ladies of Justice Award winner for both recruiting and production. She has been a Legal Shield independent associate for over 20 years. Wills and More offers many platforms for families to get their estate planning documents prepared so they can leave legacies instead of mysteries. The services provided through Legal Shield is one platform offered to simply afford families and small business owners with a legal team, including but not limited to unlimited consultation, contract, and documents reviewed, estate planning documents, special needs trust for an additional fee. Simply put, she simplifies and demystifies the business legal needs of entrepreneurs, estate planning, and identity theft protection services, all through Legal Shield's nationwide network of attorneys. Eileen has been married to her college sweetheart of 39 years, praise God, and is the proud mother of two daughters, proud grandmother to Angela and Naomi. As a longtime member of First Baptist Church of Lincoln Gardens in Somerset, New Jersey, she lives by her motto, NBGG, nothing but God's grace. I introduce and present to each and every one of you Eileen M. Marcial.
Good evening, everyone. Thank you for the introduction, and thank you, Charles, for putting this together. Because August is National Make-A-Wills Month, right? And so to me, every month is National Make-A-Will Month. But just like they have chocolate chip cookie day, purple day, they have to put a banner on things. So August is National Make-A-Will Month. And you hit the point, like 83%, I forgot what the percentage was exactly, but less than 30% of all families have a love letter will package in place. And it's been our team's mission, Charles included, and Bishop, to move that number from less than 30% to 50%, one family, one congregation, one member at a time. So I've been with the company for 24 years. I've assisted on over 800 love letter will packages. And we call it a love letter will package because a lot of folks don't like the word will. So we're here tonight so we could simplify and demystify the process. And so we could leave this lasting love letter instead of mysteries, let's leave legacies. We leave too much on the table for our families, and we need to stop that. And it's all part of generational wealth and financial literacy. So I'm going to start this. I do this presentation every Sunday at 3 p.m. Eastern Standard Time all year round. For August, National Make-A-Will Month, I do it on Wednesdays at 7:30. But in any case, I'm going to share my screen because I don't want to keep you all long, but I want to make sure that I simplify and demystify the process. So, how to leave a lasting love letter to your family. So, we're going to talk about estate planning, the basics, right? We all have an estate to plan. You talk to Charles about it, so of course, he knows what you need to do and that you need a team to make sure everything gets done correct. However, if you don't do your own estate planning, the state will do it for you, and it won't have your family's best interests at heart. Right? Now, I have a big birthday coming up next June, and I'm already planning it. I'm not leaving that to anybody. I plan my own vacations. No, I don't want any unpleasant surprises. So you don't want your family to have unpleasant surprises because you didn't do your own planning. Right? So there's a huge problem. Most people don't have a will. And why? They don't have a will because of procrastination. So I sit before you right now as one of the biggest procrastinators that ever lived because it took me 6 years to complete a 6-page document, right? Because I was intimidated by it. So I realized that what we need to do, or what I needed to do, was show people how. So if someone had taken the time to simplify and demystify the process for me 20 years ago, it wouldn't have taken me 6 years to do my will. So the mission here is to make sure that it doesn't take you 6 years, doesn't take you 6 months, shouldn't even take 6 weeks. Let's get it done in the next 6 days or 6 hours. It can be done. We can get this all done before next Sunday, right? Or at least in the works. And then some people feel they don't need one. And you know what? Maybe you don't have a lot of assets. But remember, we have a love letter will package. Will, living will, healthcare power of attorney, financial power of attorney, and mine is trust. So if you don't have a lot of assets, you may have stuff you want to take care of, like your kids, your money, your stuff, right? So we're going to check that box too. And yes, wills can be expensive. I know a friend of mine is a real estate attorney, and he charges $1,200 to $1,500 when he does his estate planning for folks. $1,200 to $1,500, right? And so the funny thing is, the irony of it is that he called me almost 2 years ago and asked if Legal Shield or Wills and More could do his will for him. He charges $1,200 to $1,500, family. He paid $360 through our service. So we're going to take expense off the table also. So what is your estate? Your estate, do you have property? Do you have jewelry? Do you have LLCs? Your estate is, what are you leaving behind? So let's go into a little more detail here. It's all of the assets you've accumulated while you are living and what you're leaving behind. Do you have real estate, bank accounts, investments? Most fistfights and family feuds occur because of personal property, right? Mama said I get the Benz. Daddy said I get the watch. If it's not in writing, people are going to be fighting. So that's why it's ever so important to get this love letter done. Do you have a business? Please put, oh, do they have a chat? Please put biz in the chat. Because if you're a business owner, you need to speak with someone like Charles. You need to speak with someone like Bishop so that you can find out what you need to have in place so that when you transition, your business does not transition into the grave with you. That's not why we build businesses. So let's make sure that your business is taken care of. And assets you control, your LLC, life insurance, do you have a corporation, retirement plans. So these are all of the assets you've accumulated. So there are 3 goals to estate planning. So the first one is managing your affairs during your lifetime. So that means your will, your living will, healthcare power of attorney, and financial power of attorney. This is particularly important when we may have a loved one that isn't at their best. They might have diminished capacity because dementia is snatching up our family members at a record pace. So what we want to do is to make sure that these documents are in place now while they're still lucid, rather than to have to go through guardianship. So manage your affairs during your lifetime. Now, when you die, these documents die with you. Now it's a matter of how do you want your estate to be distributed. So that's your executor, executrix, and if you don't get your will done, it's an administrator, and there's a fee for that. But doing step 1 and step 2, family, minimizes problems, and that's why we call it a love letter will package. So there are 3 challenges to estate planning, and I'm a huge sports fan. As a matter of fact, I watch preseason football. There's not many challenges there, but during the regular season, there's challenges in basketball, challenges even in women's gymnastics. So there's challenges to estate planning, but I am a huge Michelle Obama fan. So Michelle Obama was a box checker, right? So let's check these boxes. Getting it done. Applaud yourself. Right? You're here so we can simplify and demystify the process so you can leave that legacy. So we're going to get it done. So check that box. Finding the right attorney. I don't know if any of y'all still have one of those old dusty telephone books that they used to drop by our mailbox because it was too big to fit in the mailbox. You don't want to go through there, but you can find an attorney there. Or you can use Google, chat, or look for a billboard. But by using our services, family, each state has an esteemed estate planning attorney. So I live in New Jersey. We have the esteemed George Weinroth, who has been doing estate planning for over 50 years. But those of y'all in New York, Y'all have an amazing law firm, Feldman, Kramer, and Monaco, that is very thorough at the documents. But the only thing about New York, you know how special y'all are. I grew up there. But the thing with New York is that while most other states, anyone can notarize it. In the state of New York, your will has to be notarized by an attorney. So that's something to think about, right? But choosing the right options, I know that Charles put it in his disclaimer, but I didn't tell you all. I, Eileen Michelle Boyce Marcial, am not an attorney. I don't pretend to be one on TV or anywhere else, but I'm very passionate about making sure that we leave lasting love letters and legacies, right? So there are a lot of folks being hoodwinked. Yeah, I said hoodwinked, by folks that feel that everybody needs a trust. Truth be told, everyone doesn't need a trust. You need a trust if you have something to fund the trust with, right? So I've got folks that fell prey to folks on TikTok beating their gums about everyone needing a trust. There's some folks, some pundits that say the same. But none of those folks know what your assets are. So the beautiful thing about what we do is that you will have a conversation with an esteemed estate planning attorney in your state about what your bottom line looks like, what your net worth is based on your assets and your liabilities. You want to have that conversation with someone who sees what you have, not someone just wants to see what they can get out of your pocket, right? So definitely you're in the right place for all three of these. So let's check all three boxes. Let's talk about terminology and options. So for years, I've thrown the late great Aretha Franklin under the bus hard because the Queen of Soul had a very dire prognosis. But for all intents and purposes, it appeared she did not have an estate plan in place. She was the most fabulously dressed person I ever saw in a casket before. Gold lame gown, Louboutin shoes, and nowhere to go. But after all the fanfare of her funeral was over, there was chaos in her family. She had sons and one had special needs. Nobody knew what was going on, so it was infighting. So finally they found that she had two wills. They were both handwritten. She didn't have the best handwriting either, family, but they found two. So there was a big kerfuffle at the surrogate's court in Michigan to determine which of the two wills they were going to use. So now, once they decided that, there was peace amongst her children. So let's not leave chaos amongst our families, not when we have the opportunity to get this done. So let's not die without any planning. Powers of attorney, who do you want to speak with your doctors? And it's not a popularity contest, right? So you want them to know what you want and be clear about it. Same thing with the financial power of attorney, but in most states, the financial power of attorney comes in two forms. First is the durable financial power of attorney. That means that as soon as it's notarized, that person has power and dominion over your finances. So I don't think anybody that's on this call right now needs a durable financial power of attorney, but our mom or dad, grandma, grandpa might need that, right? So that's in place so that you don't have to go through guardianship to be able to do the things that need to be done. So we were blessed. My mother-in-law moved in with us at the age of 92. Dementia had taken hold. And so before she got to be of diminished capacity, we were able to make sure we had the will, living will, healthcare power of attorney, financial power of attorney, but a durable financial power of attorney. So when big decisions had to be made, we did not have to go to the court to do it. So you want to have these conversations while people are still lucid. The healthcare directives, what do you want at end of life? Do you want a feeding tube? Do you want to be plugged into a wall? Do you want an autopsy? Do you want to donate your body to science? If you want to do the latter or any of those, please do your due diligence while you still can. Because folks may not want to do that. They've already lost you. Now they got to figure this out. So please have things as easy and in place for your family so there's no chaos. They can celebrate your life. Beneficiary designations are amazing. But the problem with beneficiary designations is that people forget who they picked. And so, case in point, you want your beneficiaries, and I know Charles could definitely attest to this as well as Bishop. You want your beneficiaries to be one of three things. First, alive. Okay, so my mom predeceased my dad by 5 years. But when daddy died, mommy was still on as a beneficiary, as was I. But if I wasn't there, there'd have been chaos, right? So you want to make sure the person's still alive. The second is you want them to be still in your good graces. Sometimes we've gotten married and now we have a husband or once was, and we don't take them off. We don't want them still getting what you're leaving behind. So change your beneficiaries accordingly. I have a friend whose niece passed away in her mid-40s totally unexpectedly. She had been living with a guy. They broke up. He moved on. She passed away. She didn't get to take him off of her insurance policy. So this guy got $60,000 from her life insurance proceeds because he was the beneficiary, not still in her good graces. So make sure they're still in your good graces. And lastly, still in their right mind. As I mentioned, dementia is taking prisoners right about now. So you definitely want to take a look at that at least once a year. Jointly held assets. Do you own a home with someone else? Do you own property? Do you have a business? Have the conversation with your law firm for your state and they can tell you what you need to do. There's some states that have transferable on death deeds, right? So you need to know what your state does so you can have things in place so that your property does not end up in probate and ultimately a sheriff's sale. I'm going to take a deep dive on the Will family, but let me talk to you about trusts. Trusts are amazing if you need one. And that's why it's ever so important to speak with someone who sees your assets and can have an articulate conversation with you about what your assets are and what would best preserve those assets. There's a plethora of different ones. That's why you need to speak with someone knowledgeable about that. So I'm going to take you through the will questionnaire, okay? This 6-page document took me 6 years to complete because I was intimidated by it. So it's put in my spirit to show people how. And our mission is to simplify and demystify the process. So I'm going to take you through this, all right? So first and foremost, page 1, it's basic information. What is your full name? Have you been known by any other names? As you look at my name, there's a voice in the middle. That was my maiden name. But there are folks that have been married before. And okay, so let me tell you a quick story. I had a lady. She was married 5 times. She married one guy twice. Didn't work out either time, family. But in any case, all 5 last names had to be there. The membership number comes with the right and privilege of using Legal Shield to create your love letter will package. And what's your date of birth? Be exact. No sense trying to say you're forever 39 because that means you are dead. And I hope you're not on our Zoom and you're dead. That would be creepy, right? So put your correct date of birth there. Are you a citizen? If not, where are you from? Put it in the chat. Where do you live? That's pretty straightforward. But question 3 gets a little sketchy sometimes. So if you're married and everything is beautiful, you fill it out accordingly. If you're separated, write separated and your current spouse's name because you're still married to them. If you're divorced, write divorced. If you're widowed, please accept my deepest condolences because that's just sad, right? Question 4. A lot of folks get married later in life or after they've accumulated some assets. If you are going into a marriage with your own set of assets, you want to have a discussion about a prenuptial agreement, unless you want what you're bringing to the marriage to go to your spouse's family and friends too. So the prenuptial agreement is a document our attorneys can help you with, right? And it sets forth what your wishes are on the handling of what you brought into the marriage. So we got our 39th wedding anniversary was this past Saturday. When we got married, we were broken in 3 jokes, family. We were so broke. So we came home from our honeymoon, we're tearing open envelopes so we could pay our rent. And so our prenuptial agreement to each other was that we would do better. And therefore, for the grace of God, we have. So if you come into a marriage with your own stuff, definitely have a conversation about a prenuptial agreement because it becomes part of your will. Now, if you or your spouse have ever been divorced, when did you marry? Okay, I believe that the word X is just a letter in the alphabet. So I'm a little more colorful than most. So if you are a gentleman, when did you marry your first was? If you are a lady, when did you marry your first husband? I hope you're not hearing the dog in the background. If you are, I do apologize. But in any case, I hope that his frequency is off so that you can't hear them. But the thing is, if you've been married before, I work with a lot of seasoned members, and The answer I get often is, I don't recollect. And that is perfectly applicable, because if they don't know, we're not going to try to pry a number out, right? So put I don't recollect, or when you married the first, second, third, whence was, or had a husband, right? And when was the date of divorce, court rendering decision, and if they passed away. Question 6 is ever so important, because there's been a new study on autism, right? And it is spiking right now. It is spiking. It's mostly in young men. But this question number 6 most often applies to special needs trusts. So if you have anyone in your family, in your circle of influence, that has a mental or physical disability or has special needs, you need to have this conversation, because the state, in its infinite greed, will put a lien or take away the inheritance you left for a person with special needs. And they'll also take away the Social Security benefits. So let me tell you another quick story. I love telling stories. So I met a couple, they were in their 80s. Their son was in his 50s, but he was severely autistic. They were very concerned about what would happen to him when they made their transition. So we filled out the 6-page document that, yes, took me 6 years to complete. And I introduced them to Mr. Weinroth, and he created what's called a special needs trust. It was an additional fee, but it was worth the price of admission. Because now, when they make their transition, there is a trustee that's going to make sure their son is well cared for with the money they left behind. And the Social Security benefits will not be taken away because now he has money. So this is ever so important. So if you want to put down that you have a special needs trust already, or you have someone in your family that you need to discuss this with, put that down there. And do you expect an inheritance? Simply put, yes, no, or to be determined. All applicable answers for number 7. Number 8, do you have children, including adopted children? What are their full names? Are they a son or daughter? Because there are some names that are totally unisex. We don't know if it's a girl or a boy. So that's why we want that there, and their date of birth. If you have more than 4, use a separate piece of paper. Question 9A and B, I preface with, please accept my deepest condolences, because I can't even imagine losing a child. I'm a girl mom. I have 2 daughters, 2 granddaughters, 1 husband, and 2 male dogs. That's my crew. I can't imagine losing any of them, right? But if by chance you've had that unfortunate circumstance, we need to know, what was your child's name, were they your son or daughter, and when they passed away. And then we need to know their children's names so they can be included in the distribution. But please, if this applies to you, please accept my deepest condolences. So then, on a lighter note, if you have stepchildren, for years I used to sing the whole Brady Bunch theme song. But these are called blended families. And the thing is, with a blended family, sometimes it's so beautiful that you can't even tell who you gave birth to. Right? But if you want somebody that in your blended family to be included in the distribution, they need to be listed in your will as an heir. Now, on the converse, there might be some folks you flat out don't want to receive 1 plug nickel. There's a section called disinheritance for those folks. Right? Now, if you're a grandparent, put GP in the chat. If you're a great-grandparent, put GG in the chat. I'm a card-carrying grandma, so proud of it. But the thing is, there's 2 trains of thought. The first one is, God bless the child who has their own. Right? So what we believed is that when our first granddaughter was born, we changed our will. When the second one, we changed it again. So now they get their part of the distribution. But I have friends that have 30 and 40 grandchildren. And that would be very tedious to write that out. So it's perfectly applicable to say, my children will make sure their children get their share. Right? So going back to the special needs trust, this is where you're going to put down the name of the person or persons that you want to make sure the conversation is had about the special needs trust, because you don't want them losing their Social Security benefits because now they have money. Question 13 and 14 apply to families that have children under the age of 18. Who do you want to raise your children if you or the other parent is no longer here? This is most certainly not a popularity contest, family. It's not, right? So you want to pick the person who's going to raise your children the way that you would have raised them if you were still here. So I have a story for this too. One of my very best friends, her best friend, had stage 4 breast and lung cancer. She had a 12-year-old daughter who had never met her dad. So I kept asking my friend if her friend had a will, or at least a minor's trust. They kept giving me the round of mulberry bush answer. And then they put her on at-home hospice. And I told my friend to tell her friend that when she made her transition, which was imminent, that her daughter was going to Brooklyn to live with a man she never met. Not even 10 minutes later, I get a call from the weakest voice I'd ever heard in my life. And she wanted to know where she could meet me. So I live in Somerset, New Jersey. She lived in Willingboro, which is about 50 minutes away. I said, ma'am, I'll come to your house. So I drove to the house with these 6 pages and I sat on the floor because she was too sick to sit up. Filled it out. She signed it. I took it to the law firm. I told them that time was of the essence. I went back a day later, picked up the will, living will, healthcare power of attorney, financial power of attorney, and the ever so important minor's trust. Fast forward, that young lady is now 23 years old. She graduated from the college of her choice, cum laude, and is still living in the home her mom wanted her to be in. We do not want to leave our children or our grandchildren, grandparents, to an uncertain future. So if someone made you a grandparent, let's make sure that they get this done. We do not want grandparent on grandparent crime, because I know if anyone tries to get my granddaughters, it's not going to be pretty. There is an orange jumpsuit in my future. So let's make sure that we get this information articulated to our children so that they're not left to an uncertain future. So now, if by chance the guardian is horrible with money, and I've seen it happen, the law firm will vet the person. And if that person is not good with money, you're going to check no, and you're going to pick 2 other folks. Actually, I'm sure Charles and Bishop might be able to help you have that discussion of what might be best to make sure the special needs, not the special needs trust, but the minor's testamentary trust reflects what needs to be reflected and what age do you want your children to receive their inheritance. Right, so question 13 and 14 is the minor's testamentary trust. It's included in our services. So this page here, asset allocation, oh my goodness, it's crazy. The crazy thing about it is that there's so many words. And when people see a lot of words, they don't want to read it. Okay, so I like to compress it because I'm a closet teacher. So option A, I'm married with children. So if your spouse is surviving, to your spouse. If your spouse predeceases you, to your children in equal shares. If one or more of your children predeceases you, that child's share goes to their children in equal shares. If the unthinkable happens and there's no one left at all, where do you want your assets to go? And that's where those lines are. Your church, your charity, your fraternity, your sorority, whatever you want to leave it to, that's what those lines are there for. Option B is the same as option A without the spouse. So in equal shares to your children. If one or more of your children predeceases you, to that child's children in equal shares. If everyone's all gone, where do you want it to go? But over the past 6 years, since the pandemic, I've realized that people like to freestyle the answer. So option C, you could be as exact as you want. You want your home at 123 Main Street to be sold and the proceeds distributed in 4 parts to this person. Whatever you want, put it down there. This is your option to put what you want and how you want it. So that's the asset allocation. So all these words, yeah, they're there, but I hope I made it simpler and easier for you to understand. Disinheritance, remember I told you if there's a family member that you don't think should get what you're leaving, disinheritance is the option. But when you want to disinherit someone, please make sure you have a conversation with your local George Weinroth so that it sticks. Okay? If you don't want somebody to get your stuff, you want to make sure that they don't get your stuff. All right? I touched on this before. Healthcare power of attorney. Who do you want to speak with the doctors if you're not able to? Right? So if that's the case, we need the full name, address, and phone number of that person. Right? And so what I always tell folks is that once this document is created and once you have it notarized, you want your representative to have the healthcare power of attorney in their phone. So when they get that unfortunate phone call, they could say, no, doctor, I have the healthcare power of attorney. Do you want me to email it to you, text it to you, or fax it to you? It puts the ball back in your family's court, right? And the beautiful thing about our services is that we will create a healthcare power of attorney and financial power of attorney for you, your significant other, and any never married children between the ages of 18 and 26. So for the most part, most states, once a child turns 18, we as the parent are no longer able to speak to the doctors. We could pay the bill, we can't talk to the doctors. So now the ball's in your court. The question next that needs to be answered is, do you want the person to act on your behalf immediately or only when the doctor says you're no longer able to? So that's a personal choice, right? So I'm old school. So I like paper will questionnaires and I put purple ink on it and I send it to the law firm. But there's other options. If you are tech savvy, you can do it in the app. Or if you prefer to use your desktop, you can do it in a portal there. The main thing is we got to get it done. Question 17 also doubles for the financial power of attorney. If the person or persons you selected to be your healthcare power of attorney are not the same people you want as your financial power of attorney, purple pen, asterisk next to 17, and write financial power of attorney and name the people you want. And this is also important if you need a durable financial power of attorney for a loved one who has diminished capacity. All right, so that's that. Executor, executrix, who do you want to distribute your stuff when you're not here? It is not an easy job. So you want to pick a person that has broad shoulders and strong intestinal fortitude because they're going to be hit with an onslaught of people who feel entitled to your stuff. So if you're married and everything's cool, you check yes and pick one alternate. If it's not cool, you pick two alternates, right? And then the fiduciary bond. Most often, we pick a friend or a family member, someone who does not have a financial responsibility to your estate, like a banker, financial planner, accountant, insurance agent, lawyer. They have a financial responsibility. So most often, the answer is going to be yes. You're going to waive the fiduciary bond. Special provisions, it's the same thing as option C, but you really don't want people fighting over your trumpet or your Rolex or even, I have my great grandmother's slatted spoon. That spoon is way older than me, but I have it. It's falling apart, but has sentimental value. You don't want people fighting over sentimental value. So that's why special provisions is important. So guess what, family? We're on page 6 of the 6-page document that took me 6 years to complete. So the optimal word or the operative word here is approximate, estimated, right? So do you own your home? How much is it worth? Does your spouse or someone else own it, or do you own it with someone else? How much is it worth? If you own more than one property, use a separate piece of paper and do you own it? Where is it? All that good stuff. Checking savings, credit unions, and certificates of deposit, we only need the financial institution name. Because once you pass away, your will becomes a public record. Account numbers are personal identifiable information. We don't want personal identifiable information on a public record. So in those lines, I want you to put payable on death, transferable on death, or beneficiary on file. And remember, we need them to be alive, still in your good graces, or still in their right mind. So that's what we're going to put. If you don't have them, go to the bank and assign someone there. Or even better yet, if you have someone you know, love, and trust and doesn't have a whole lot of creditors chasing them around, you may want to have them on your account. I was on my dad's. I was on my auntie's, it's because I don't get into trouble, but some people do. And so you want to make sure you choose wisely. Do you own a car? Then it's an asset. If you leased it, then it goes back. Do you have stocks, mutual funds, or other investments? A qualified 401k or retirement plan or life insurance, beneficiary on file, payable on death, transferable on death. You got experts online for that. And I'm sure there's some experts in the call. So you know what has to happen there. We're not leaving that to minors. That's why we have a minors trust. Now, if you own a business, you need a succession plan. Our attorneys can help you with that. So you put that down. I have a succession plan. You attach it to your will. It's part of your wishes. So this way your business does not die with you. I found out the answer to what's miscellaneous. So some people will say what do you call it? timeshares. That's a miscellaneous. But also, we do have a gun owner supplement. And the thing about a gun owner supplement is that if you leave an array of firearms to someone, you need to make sure the serial numbers match up and who is supposed to get it. Because if one of those guns gets away and is involved in the commission of a crime, that legacy you left of that amazing firearm collection now has become a liability to your loved ones. So we need to be on point with those things. So those are your assets. We're going to separate out or subtract your mortgage. What do you owe in your car? Do you have a HELOC? Do you have student loans? Do you have medical expenses or debts over $5,000? So this page is page 6. This is the one. This is the one where you have the conversation with the law firm because now they see what your assets are. And then the articulate conversation can be had about whether or not you need a trust or not, right? So as I mentioned, this is the page where you can have that conversation. And I just want to remind everybody, less than 30% of families have it because they don't like the word will. Now we can simplify and demystify that process so we can get it done. All right. So a little bit more information, and we're going to open up for questions. I learned at the beginning of the pandemic that a lot of folks don't have those old school telephone books where you wrote phone numbers in. So when my dad passed away 15 years ago, Daddy had one. So I sat down and I called the folks in there to let them know what the arrangements were. I don't have a telephone book. Do you? If you do, put a phone book in the chat. However, now everything's on a digital asset. It's either on our phones, it's on a laptop, it's on a tablet, it's on a thumb drive. Somebody needs to have access to be able to modify, delete, control, and transfer those digital assets, right? But what is a digital asset? Let me take you through that. So, do you have an email account? I'm sure everybody has at least one. Those need to be shut down when you're no longer here. So someone needs to have access to the passwords and the contacts, right? So we shut those down. When we shut those down, then there shouldn't be fraud going on. The same thing with social media accounts. I'm not good with it. However, you need someone that has access to your platforms. So a well-worded in memoriam page can be put up so that people can't still be doing stuff and fraudulent activity on your social media account. If you have crypto or non-fungible tokens, you need to have a beneficiary on file on your virtual currency wallets. And if you don't, they die with you. Because the beneficiary on file allows for someone to have access to your 12 or 24 character phrase or password. If not, as I said, it dies with you. We have digital storage, reward points, online shopping, business services, photos, books, dating apps, gaming, and streaming. All of those have passwords. Someone needs to have them so they could be shut down. So those are the digital assets. But we also have a service that can protect those things. We have a service called Identity Theft Shield, ID Shield. And with that, my favorite part of it is the password manager because it allows you to name up to 6 friends or family members so that when you're no longer here, they have access to your contacts and your passwords. So there's not going to be that chaos of someone trying to jailbreak your phone and try to figure out who's who, what's what. So you want to have something in place. You might have something on your phone. If you don't, please, let's have that discussion. In addition to that, they create hard to hack passwords. So keeps me out of trouble. But every week I get an email from some clown pretending to be Chase Bank. And I know it's a clown because it says Chase, but it's CHA $E. We all know there's no $sign in the Chase logo. But in any case, folks figure they're going to try anyway. So we have our own technology that's going to be able to go over, they let you know that, oh, no, this isn't good. Don't click on that. And then everywhere we go, there's free Wi-Fi signs. And the problem with free Wi-Fi, it gives free access to hackers to your data, your information, and your credit. So we offer you a virtual private network. So the price of peace of mind and protection, we get discounts. I don't know if you like discounts, but I love discounts. And we have discounts with over 400 different companies. So I run in Adidas. My husband wears Ray-Ban. I walk in Reebok. Told you about my 2 sweet granddaughters. Car seat, strollers. It's got a booster seat for the 3.5-year-old because she's the height of a 5-year-old already. Enterprise, great discounts. Costco's, I live there. and we all have cell phones. So you can get discounts on the device as well as the accessories. And I run on a really high level of energy, so I light a Yankee candle every night in the scent of lavender so I can fall asleep and wake back up. But I'm going to give you a deeper dive on the price of peace of mind and protection. We have a basic plan. It's $29.95, and it is basic. Okay, it only covers the member and spouse. There are no revisions. It's one and done with the will. And if you do drive, you have to wait 90 days to, if you get a moving violation, we will represent you for one per year. We review contracts and documents up to 15 pages. So the basic plan is for people who don't have children or drive a lot or have an extremely fixed income. The preferred plan is the sweet spot, right? It covers the member, the spouse, and children up to the age of 26 that have not been married. We do one revision a year because life changes. I had a woman who hit the lottery. She hit the Powerball for $18 million. We had to revise that will. In fact, she needed a trust. But the thing is that when it comes to moving violations, you only have to wait 10 days before an attorney will go to court with you for a $79 court appearance fee. It's two per year per licensed driver. This is a powerful thing to have. And we will review contracts and documents up to 25 pages, unlimited in nature. But the premium plan is $49.95 per month. It covers everything that the preferred plan has, and then it covers 3 moving violations per year, and you can carry over 2. And then we have a basic revocable trust for you and your significant other for $250. The caveat is, though, that basic is at the discretion of the law firm. So that's why that page 6 is so important in the will questionnaire. So the basic revocable trust for you and your significant other, and what I don't have on the screen is we would do simplified probate. An absolute oxymoron if ever there was one. However, when we have done the will for your loved one, we are going to work with that executor, executrix, so they can know what they need to do to get the probate process started. And we review contracts and documents up to 35 pages. And if you want to protect your digital assets, now the individual plan is $19.95 per month and covers up to 3 devices. Family plan covers up to 15 devices for $34.95. That $34.95 covers you, your significant other, and children up to the age of 18. Your children between the ages of 18 and 26, we do consultation and restoration for eligible children ages in that age group. So I have found that there's so many different platforms that we can offer estate planning services with. But the thing is that most people feel priced out of it. And so that's why I love what we do. And I hope this simplified and demystified the process for you. Made it easier for you to say, hey, look, I need to get this done. Can we talk? So whoever invited you on this webinar, please reach out to them so you can have the discussion. Get that will questionnaire filled out. Download the app. Use your laptop. But the main thing is let's see what we can get done in National Make a Will Month. Let's move that number from less than 30% to 50%. One family at a time, one congregation at a time, one family at a time. So I thank you so much for I want to see a lot of grandparents on the line. Yay, yay. It's the best thing ever. My mom told me it would be, and I just love, love, love it. So yes, now I'm here. If there are any questions, any comments, I'm just happy to be able to share this with y'all this evening. I hope it simplified and demystified the process.
I don't see any questions in the chat, but that was a great presentation. Very, very informative. And
Thank you.
when you was talking about that page with the assets over liabilities, a lot of people think when they pass that the debts pass with them. But
Mm-hmm.
I know firsthand that those debts go right to probate court.
Oh, yeah.
And the judge would attach a lien, and those debts has to be paid.
Yes.
The
And
mortgage, the car note, all of that stuff has to be paid.
absolutely, especially if the property, car, whatever it was in the name of the person who passed away.
Mhm.
If it's not in writing, it's going to go to probate. I have a gentleman in Illinois, his wife died in December of, let's say, 2022. He was not able to finally do what he needed to do until December of 2023, even though they were married. So it's not just a straight, oh yeah, automatically goes to my family. Doesn't work that way in most states. So that's why I love what we do. So I see the question about why is it a monthly plan? What is the flat fee? Okay, so I get that question often. So some people it's more of a fixed income, it's easier to do it in individual chunks. And so the 29.95 plan, if you pay for the year, I don't have that in front of me, so let me just get that up for you. Hold on one second. One second.
What are you looking for?
Oh, what the annual fee would be. I have it here. Okay, so if you were to do the basic plan, the annual fee, if you wanted to pay one time, you're looking at $324 instead of $360, which is 30 times 12. The reason that it is, this is a Legal Shield plan. And what I was able to extract from it 12 years ago is that you're able to get your will and so much more done for either a monthly fee, and if you like all the other services, you keep it. If you don't like the other services, you could be one and done. We'll let you know. We'll reach out to you right before your year is up. Say, hey, do we need to make any changes? Changes need to be made. We make those changes, and then you're free to cancel. Our mission isn't to just make you continue to pay in perpetuity, but if the services warrant that, then you need to make sure you got those 2 tickets a year, that 24-hour day access to an attorney if there's an emergency situation, right? So if you wanted to do the basic plan, it's $324 if you wanted to pay one time. If you wanted to do the preferred plan, you're looking at $410 for a one-time payment. And if you want to do the premium, you're at $540 one-time payment. So I hope that clarified it because this is a membership through Legal Shield, and I find that this is the most cost-effective way to do it, but there are other ways. That we have attorneys you could just sit down with and pay them their comma in the price tag if you so choose.
And there's another question in the chat. It says, do you service an irrevocable trust?
Oh, we do. So the basic revocable trust is $250. The irrevocable trust, it depends on how intricate your assets are, right? And so that's a conversation you have with the law firm as to what the price point would be for that trust. I've heard 1,500, I've heard 15,000, depending on what you have. I hope that helped.
So there's another question. Will there be a replay? Yes, I'm recording. So yes, there will be a replay. We'll actually reach out to everyone, send an email. I only have emails. We'll send an email out. Whoever has my information can contact me as well. If anyone has a question, we have a few minutes. You can unmute. I see there was Georgina and Claire had their hands up for
Awesome.
quite some time. You still
Hope you
have
aren't so tired.
you still have a question or someone, here we go. Somebody just raised their hand.
And while you look for the person, what's really cool is that every Wednesday at 7:30, at least for next Wednesday is the last one. It's the last Wednesday in August. But every Wednesday at 7:30, I do the same presentation. Sundays at 3 p.m. Eastern Standard, I do the same presentation. And so my mission is to get as many people in front of it so they can see that we simplify and demystify the process.
All right. So Barbara, I see you there. You can unmute yourself for now.
All right. Hello, everyone. Hi,
Good
Eileen.
evening. How are you, Miss Barbara?
I'm doing great. I didn't see where I could put myself on camera, but that's okay. I missed some of it, so I do want to go back. I definitely need your help and your services.
Awesome.
So I will be reaching out to you as soon as possible.
Awesome. I appreciate you.
Thank you.
Absolutely. So just for the record, I'll put my information in the chat.
In the chat, okay. I don't see.
And if anyone needs a copy of that 6-page document,
Yeah,
I can make sure you get it once we get the emails out to everyone.
okay,
But you could text me.
okay. I certainly will.
Absolutely.
All right.
Pleasure meeting you.
Nice meeting you too.
Thank you
I
so much.
need to reach out to you as well, Charles. We need to play some catch up.
Yeah,
Awesome.
absolutely. Yes, yes.
Mhm.
Thanks for joining the
Yes.
call.
Thank you everyone for taking time out of your Thursday evening. Missing what is on right now? I guess Celebrity Family Feud.
Oh
I'm a
my
game show
gosh.
junkie. I'm a game show junkie, so I've been cooking
Okay.
it just so you
Yeah,
know.
I was driving trying to get here on time, but it didn't work out that way. You know how that goes.
You know
Well,
what? It's all good. I'm glad you're here.
we have
Thank
a
you.
recording. I'll upload it and send it to everyone. I have the emails. I guess we have time for a couple more questions, I guess, and then we'll wrap it up. Um,
Awesome.
I know I did have a question. You was mentioning about the a special needs trust with
Yes.
a minor and social security. I didn't really catch that. You said
Oh
you
my
knew someone
goodness.
that the social security for the special needs child. Can you
Yes.
go through that again? I'm sorry.
Oh, absolutely, absolutely. I have a presentation tailored for that, especially because what happens is that when a child has special needs, the government, in its infinite greed, because they've paid Social Security, whatever reason, they feel compelled to put a lien on what the inheritance is for your loved one with special needs, mental or physical disabilities, right? And so our special needs trust addresses that. And you pick who you want to be the trustee over what you're leaving behind for the child. Special needs trust can range anywhere. It depends on the state from 500. I know most often I see 1,000, but sometimes it all depends on how detailed and how intricate it is what you're looking to do for that child. So special needs trust is a conversation you have with the law firm so that they could draw it up. I will send you a retainer form, and then they will create that trust. So that's what happened with my seasoned couple in their 80s for their son in his 50s. So that now when they make their transition, they're not going to be worrying.
Uh, hold on, let's mute. Sorry about that.
That's okay.
Okay.
Awesome. So yes, if you like, at some point, I would gladly do the special needs trust overview for you because what it does, it just sets the tone of why you need it and why you need to speak with our attorneys to get it done. Because I have a friend that paid $13,000 for a special needs trust, and she didn't need to do that much.
It's time for one more question.
And can you share the flyer for the Zoom on Wednesdays and Sundays and the link? You have it, so if you can share that when you send the email out for
I'll
folks.
send that out. I'll send it out.
Awesome.
All right.
Yay, yay.
Anything, Miss Linda Bishop, before we wrap it up?
No, I just thank God for Eileen because this was very, very informative and very necessary. And just want to thank those of you who, my friends who came out and family members to hear this great
Awesome.
presentation because it is needed. It really is needed.
Thank you so much, and let's get it done.
Mhm.
All right, great. So thank you, everyone. We'll just wrap up, and it's 8:30. We actually stayed within the time. Can you imagine?
Absolutely.
We
That's
started
that.
on
I mean,
time and
that's
finished on time.
yay, yay. Okay, hold on. Let me get my favorite thing again.
Yes, you did an awesome job.
Yes,
We appreciate you.
beautiful.
Like you said, the main thing is get it done.
Absolutely.
We work in this field so much, and I just hear horror stories and assets going to probate court, people passing without it, and it goes to probate court, and that could be
Yeah.
2, 3 years, and
And a lot of money.
the fighting and everything's all good, and then all of a sudden it's not all good, siblings not talking, all kind of stuff going on, and this
Family
really
feud.
helps smooth the transition, and like you said, you can leave it to the church, you can leave it to the charity, your business. We didn't talk about the business plan much, but there is one plan specifically for business owners. I know I use that all the time. Actually, that's the first program I had, the plan. So, what we'll do, I guess we'll send an email
Okay.
out with everyone's contact information, and we'll try to reach out and talk and schedule some more appointments. And everyone, y'all have my contact information. I'll share your information with Linda. And all right. So with that
Awesome.
said, I guess that is it for now. And I will definitely be sending out the recording. And I
Awesome.
appreciate everyone joining. I hope you found very much value in the presentation. I know I did. I always does. All right. Thank you so much, Amanda. And everyone, we will see you later. Have a great
Thank
one.
you so much. Have a
Okay.
blessed
Good night,
evening,
everyone.
everyone.
No
God
problem.
bless everyone.
Take
Be
care.
Take care.
safe. Stay off the beach.